Good morning, everyone. Welcome to our bite-sized session on the Employment Rights Bill. Could you pop onto the next slide, please, Tom? So in order to deliver this session, I've had to overcome FOMSO. Some of you will be familiar with FOMO, fear of missing out. Well, lawyers often suffer from FOMSO, fear of missing something out. We are trained to be thorough, to look at all the angles and make sure that we cover everything. But in half an hour, I can't cover everything about the Employment Rights Bill, and I won't. The reason why I won't, a number of reasons. First of all, the timescale for implementation is A, unclear, but B, the suggestion is that the majority of reforms are unlikely to take place before 2026. So that means I could cover something today that you don't necessarily need to know about for another 18 months. So I'm less worried about missing some stuff out. The second reason is, whilst I can't see you, I know two things about you. First thing I know is that you're busy people, hence the half-hour time slot. The second thing is that I know you're intelligent people. You are perfectly capable of Googling and finding a summary of what is contained in the Employment Rights Bill. Some of you may even have put the Employment Rights Bill into ChatGPT or Copilot and asked for it to generate a summary for yourself. You can do that. You don't need to know everything that is in the Employment Rights Bill for the purpose of today. What I want to concentrate on is the areas of the bill where I think businesses and HR professionals can start being proactive now in order to prepare for implementation. So if you pop onto the next slide, please, Tom. So this is what we're going to look at, and these are the areas where I think businesses can be doing stuff now, or at least thinking about doing stuff now, to get themselves ahead of the game. Just to mention, there is a Q&A function within the setup, so if you do have any questions, feel free to pop them in there. I don't know whether we'll have time to get round to them. If we don't, I apologise in advance, but that doesn't stop you popping them in there. Could you go to the next slide, please, Tom? So, employment contracts. What should you be doing about your employment contracts now? And this relates to the issue of what's called fire and rehire, what we used to know in the old days as termination and re-engagement. So, a bit of a history lesson here. Many of you will remember a few years ago, a lot of controversy called by P&O entering into a process whereby they terminated about 800 employees and they re-engaged different agency workers on different terms and conditions. And this led to the concept of fire and rehire getting a lot of negative publicity. The Conservative government, as a result of that, issued a statutory code of practice indicating the way in which it felt that employers should go about termination and re-engagement exercises. They've been around for many years, and they've been an effective way, an effective last resort for an employer implementing changes to contracts of employment that it has been unable to agree with employees. As a result of a lot of the publicity, then before the election, the Labour Party said that they would be ending the scourge of fire and rehire practices, which by some was taking as a suggestion that they were going to ban the practice. The Employment Rights Bill doesn't ban the practice outright, but there are some extremely robust provisions in there that I think will significantly reduce the scope for employers changing terms and conditions by way of terminating a current contract of employment and offering to re-engage on new terms. So the provisions within the bill are that a dismissal will be automatically unfair if either the reason for the dismissal is because an employee refuses to agree to a variation to their contract of employment, or the reason for the dismissal is the employer wants to replace the employee or re-engage the same employee under a different contract, but to do exactly or substantially the same job. So effectively, they want to change their terms and conditions. That would cover most termination and re-engagement exercises, because that's what's happening in a termination and re-engagement exercise. You are proposing changes to, I don't know, shift pattern, pay rates, overtime rates, whatever they may be. The employee will still be doing the same job, but you want to change their terms and conditions. The reason why it isn't an outright ban on termination and re-engagement is there is an exception. I've set that exception out there on the slide. So where it is a business survival critical need to change terms and conditions. So the reason is to eliminate, prevent, or significantly reduce financial difficulties likely in the immediate future to affect the ability to carry on the business as a going concern. So i.e. it is business critical, and the employer couldn't reasonably have avoided the need for changing terms and conditions, then a termination will not be an automatic unfair dismissal in a termination and re-engagement exercise. So, for example, you're a business that suddenly loses your major client, you have a huge shortfall, and you need to go to employees to say, can everyone agree to a 10% pay cut for the next 3 months to get us by until we get back on our feet? Otherwise, we're going to have to close the doors. That's the sort of scenario that this anticipates. Interestingly, it talks about businesses, so it's unclear whether that means that it will be completely impossible to do termination re-engagements in the public sector. We'll have to wait and see on the detail. The other things added in within the Employment Rights Bill that they are considering, so they're not in their bill at the moment, but as part of the consultation exercise will be considered, is providing for what they call interim relief, which is a sanction that is rarely used in the employment tribunals at the moment, has a very limited scope, but effectively that's a sanction that means a dismissal would be put on hold until a tribunal can determine whether or not it is unfair. So effectively it stops the dismissal and would preserve the existing terms and conditions of the employee. And the other thing, as another stick to prevent employers carrying out these exercises, would be to increase the protective award, currently at 90 days pay per employee. They've not said where that might increase to. So there are some very robust provisions effectively seeking to prevent employers going through termination and re-engagement exercises. If you pop onto the next slide, please, Tom. Employers will still be able to agree changes to contracts of employment. There's nothing to stop that happening. Where my concern for businesses would be in relation to these reforms is, take quite a common example that I've come across in practice, which is, let's say you've got 100 employees who currently work a 2-shift pattern. And for various efficiency reasons, you want to move to a 3-shift pattern. And there's going to be no reduction in pay for employees. In fact, they might get paid more under the new system. But it is a change to their contract of employment. So you consult with employees, and out of your 100 employees, 96 of them agree and 4 of them don't agree. And the 4 who don't agree. They don't care about the money. They don't care they're going to earn more in the new regime. They like playing golf together on a Friday afternoon. This is going to stop them play golf together. So they're sticking their feet in and saying, no, we're not going to agree to the change. In order for that shift pattern to work, you need everyone to be on it. So you need those 4 to be on it. And what you would do at the moment is you would say, look, sorry, we've tried everything we can. We're going to have to terminate your current employment and offer you re-engagement on these new terms. If you don't want it, that's fine, but we think that would be a fair dismissal because we've tried everything we can. Under the new regime, that would be an automatically unfair dismissal, as I read it. And that's the concern I would have for employers. So what could you be doing about that now? So my challenge to employers now would be, for new employees starting, if you had within their contract of employment a provision that said, these are your current hours of work, but we reserve the right to vary these hours and shift patterns depending on our needs from time to time and perhaps after appropriate consultation. Then in respect to those 4 employees, you wouldn't have to terminate in order to enforce the change. You would have the contractual right to make the variation. In the same way that lots of employment contracts now have mobility clauses that say this is your place of work, but we may change it from time to time to another reasonable place of work. We may change your duties from time to time. I query whether you could have a flexibility clause around pay, but that is something worth thinking about. Now, it may be something we ought to be whispering about, because I did hear some commentary suggesting that perhaps once they're consulting about this reform, the government might think that they don't want people to try and avoid what they're trying to do and might amend the regulations to try and prohibit such flexibility clauses. But I struggle to see how they could stop an employer and employee agreeing to a reasonable flexibility clause. So I would recommend that employers review their contracts of employment, and certainly for new employees, try and consider whether there is some scope for implementing some flexibility clauses. That would mean if they want to make changes in the future, they might not have to do so by way of termination. They might be able to, within the ambit of the contract, be operating within the contract and varying the contract as they're permitted to do so. Next slide, please, Tom. Okay, so moving away from contracts and on to training programs and upskilling employees. So one here, grabbing a lot of headlines in the Employment Rights Bill, is this concept of day one unfair dismissal rights. A couple of things to mention here. The first is the government have been very clear, whilst the implementation dates on other areas are unclear, they've been very clear that this will not happen before autumn 2026. At the moment, we have 2-year qualifying service to bring a claim for unfair dismissal. That will disappear. That will disappear. However, following consultation with businesses, day one unfair dismissal rights won't be absolutely pure day one unfair dismissal rights, because the bill introduces this concept of an initial period of employment, which is effectively a probationary period. The government has said its preferred length is 9 months, but it's open to consultation and persuasion on that. It's unclear exactly what that initial period of employment will look like and how it fits within the general ability to bring a claim for unfair dismissal. 2 suggestions that the government has mooted at the moment for discussion are, first of all, introducing some sort of process, and a very basic process, that has to be followed if you are going to terminate someone during that initial period. So to say, well, you can't claim unfair dismissal in your first 9 months if the employer has at least followed this basic process, which might be a meeting and a decision in writing. It might be more detailed than that. The other thing that is mentioned by the government is what it might do is unfair dismissal. At the moment, you get maximum compensation of a year's pay or £115,000, whichever is the lower. What it might do is for a dismissal during that initial period, whether it be 6 months, 9 months, 12 months, whatever they end up with, whether that might be a lower maximum compensation. But we don't know the detail about that. We don't know the detail about that. So what could businesses be doing about this now? Well, whilst we don't know the detail, what we do know is at some point in the future, it will become more difficult to terminate employees during their first 2 years service, and probably more difficult during their first 9 months service. There'll be a process to be followed. So what could businesses be doing now? The first is working on improving recruitment skills and recruitment systems. I know there's lots of employers looking at benefits of AI and trying to use a combination of AI and human recruiters to improve the quality of people they are recruiting, which will mean they have fewer people who come in and just don't fit the job and employers need to terminate in the early stages. So that's one thing businesses could be doing now. The second thing to mention with these reforms and the day one unfair dismissal rights, this initial period of employment, this sort of statutory probationary period, won't apply to redundancy terminations. So as drafted at the moment, from day one of employment, employees will be protected from being unfairly dismissed on grounds of redundancy. So businesses will have to get those redundancy processes right for all employees, not just as they do at the moment for employees with more than 2 years service. So upskilling managers and HR on carrying out proper and fair redundancy processes will be important. Next slide, please, Tom. Okay. Duty to prevent sexual harassment. As some of you will know, coming in next week, for all UK employers will have a duty to take reasonable steps to prevent sexual harassment in the workplace. The Employment Rights Bill has two additional points in relation to that. The first is at some point in the future, again, we don't know the time frame, that duty to take reasonable steps will be a duty to take all reasonable steps, which will be a higher duty. Exactly what it looks like, we don't know, but what is certain is it will be a higher threshold for employers to fulfill. The second important thing contained within the Employment Rights Bill is an obligation or liability for employers for harassment of their employees by third parties. So at the moment, the duty to prevent that comes in next week says employers should take reasonable steps to prevent employees being harassed by third parties, such as customers or attendees at a conference. But the employee can't at the moment bring a claim against their employer, a standalone claim to say, I was sexually harassed by a customer and you, my employer, should be liable for that. When this new law comes into place, the employee will be able to bring that claim if they can establish that they were harassed by a third party and that the employer failed to take all reasonable steps to prevent that harassment from happening. So what can businesses be doing now about that? Well, as we've identified in relation to sexual harassment for a number of clients, and as the EHRC set out in their technical guidance, employers should be carrying out risk assessments now to identify where there are risks of harassment by third parties. Just to make it clear, at the moment, the duty to prevent relates to sexual harassment only. Under the Employment Rights Bill, the liability for third-party harassment will relate to all forms of harassment. So harassment on grounds of disability, sex, race, age, all forms of harassment. So businesses now, in order to prepare for this duty, should be carrying out these risk assessments to identify areas of risk and try and manage those areas of risk. As also businesses are being encouraged to do now, they should be encouraging employees to report third-party harassment, bystanders to report third-party harassment, so businesses are aware of where this is happening, aware of where their risks are, and can address those risk areas before this liability is introduced in a couple of years' time. Do you want to go to the next slide, please, Tom? Flexible working requests are covered in the Employment Rights Bill, and there is going to be some further reform of flexible working requests. We've had some recent reform on it, and just to capture where we are at the moment, flexible working, they're already a day one right. We know that, and we know that people can now make up to 2 requests in a 12-month period. There's already a process to be followed, which includes consultation with an employee. And there is already a list of statutory grounds upon which a request can be rejected. And an employer failing to follow the process is subject to a compensation award of up to 8 weeks' pay. But essentially, what the employer has to do to comply at the moment is to fit their reason for rejecting a flexible working request into one of those statutory grounds. What will be new under the Employment Rights Bill is that employer will have to justify that their decision not only fits within one of those statutory grounds, but it is reasonable for them to have concluded it fits into one of those statutory grounds. And they will have to explain in their decision process why it was reasonable to the employee. And so there is the possible of increased claims from employees who've been rejected for flexible working, because the employer will now have to justify why their decision was reasonable, and it's not just a paper exercise fitting it into one of the 8 grounds. What can employers be doing about that at the moment? I know a number of employers are already doing this in light of the recent reforms on flexible working requests, is training managers in dealing with flexible working requests, how they deal with them. Historically, there has always been a potential additional liability involved in rejecting a flexible working request outside of this maximum compensation of 8 weeks pay. And that additional liability has been the risk of an indirect discrimination claim. So to give an example, an employee, female employee who's in a full-time job asked to go part-time due to childcare responsibilities. If an employer rejects that request, there is a risk of the individual claiming indirect sex discrimination because the employer is imposing a requirement to work full-time. Fewer women than men can comply with that requirement because more women than men have primary childcare responsibilities, and therefore on the face of it is indirectly sex discriminatory, and the employer therefore has to justify why that job can't be done on a part-time basis. That's always been a risk. That's always been there. Recently, we've seen reform to the Equality Act in Section 19A that means that a man who makes a flexible working request for childcare reasons and is rejected could also potentially bring an indirect sex discrimination claim because he suffers the same disadvantage as women with childcare responsibilities. So the scope for claims in relation to flexible working requests is already significant. The obligation to have to justify decisions as reasonable will make that more significant, and training, particularly managers and HR in dealing with flexible working requests, I think is something that could be done in this interim period, again, to get ahead of the game and avoid liabilities once the law is reformed. Next slide, please, Tom. It's no surprise that bill produced by a Labour government has a number of provisions in it designed to strengthen trade unions and increase trade union visibility and activity in the workplace. Some examples of this are the requirement on employers to notify employees of their right to join a trade union, the right of a trade union to request access to a workplace. That's for the purposes of meeting employees, representing employees, recruiting members, organising to facilitate collective bargaining. Importantly, it is not for the purposes of organising industrial action. The way it's framed is it's a right to request access to a workplace. The employer can grant that access and can negotiate about what the terms of that access will be. If the employer rejects the request, then the union is then able to go to the CAC, the Central Arbitration Committee, who will decide what is reasonable in all the circumstances in terms of access to the workplace. There are proposals to make electronic balloting available in the long term, so that might make industrial action more likely to be called if more people make use of electronic balloting than the current postal balloting system. And the other thing to flag is making statutory recognition of trade unions, making that process easier. At the moment, there's an initial threshold of 10% of employees. That will be changed to somewhere between 2% and 10%. They haven't yet decided where. But the general theme is one of increasing visibility and activity for trade unions. Now, I'm very careful not to get political here. Some people and some employers will have the view that trade unions are a force for good and can help the business and help it grow, better employee relations, etc. There are other employers who I appreciate are very wary of trade unions, historically haven't had recognised trade unions or much trade union activity or membership and want to keep it that way. Make no comment on either of those positions. What I would say to the employers who are nervous about increased trade union visibility is bearing in mind that these reforms, again, won't take place for another potential 18 months, is now is the time to be looking at a strategy in relation to the collective relationship you have with employees, employee councils, information and consultation forums, etc., to try and establish a position where employees and trade unions may not be required. There may not be that desire if employees feel that they have a sufficient internal collective bargaining process. So that's something for some employers to consider. Next slide, please, Tom. Final thing to mention in terms of the proactive strategies is to look at some cost modelling. There's a number of areas where there is some obvious added cost to some reforms that are coming down the line. Difficult to do precise cost modelling, I appreciate, because the timescale for implementation isn't clear. But when you're looking at things like paternity leave from day one, importantly, I know for a number of businesses that only operate SSP at the moment, SSP, statutory sick pay from day one. At the moment, there are 3 waiting days. Employers need to be thinking about, well, what's the increased cost if every employee is entitled to SSP from day one? And I know some employers are thinking about, will there be increased absence as well? Will the Monday morning hangover absence be more common in a world where someone's going to be paid for that absence, as opposed to at the moment where they don't get paid for it? Outside of the Employment Rights Bill, because it's dealt with by the Low Pay Commission, but nevertheless coming, is removal of age bands from national minimum wage. So for businesses that have a lot of younger workers in the lower NMW age bracket, to be thinking about cost modelling around that. And there will be an obligation to publish a gender pay gap action plan for employers with more than 250 employees. Again, in terms of that action plan for addressing gender pay gap, and in the future we'll also have, we think, disability pay gap and ethnicity pay gap reporting obligations. That costs money to address that. So there'll be some cost modelling involved. Next slide, please. Okay. Finally, just to mention, again, one of the big headline grabbers is reforms to 0 hours contract, and in particular, the right of workers to get a contract reflecting guaranteed hours based on their average hours over a particular reference period. A lot of the publicity before this referred to a 12-week reference period. That doesn't actually appear in the Employment Rights Bill. It just refers to a reference period, and that period is going to be determined in the future. I know there is some pressure on the government to go beyond 12 weeks because the impact of a 12-week reference period, particularly for seasonal workers, is a concern for some businesses. So if you've had an employee who's been working long at 0 hours, or casual employee who's been working long hours, October, November, December, leading up to Christmas, is it right that that employee is then entitled, as of January, to a contract reflecting their hours from October to December and guaranteed hours at that? There is also potential administrative burden on employers. The way it is currently drafted is it isn't a right to request guaranteed hours. It is an obligation on the employer to be monitoring people's hours and to be periodically offering guaranteed hours contracts. And the reference period, when I say that it will be different for each worker, it will be the same length of time, but when it starts for each worker will be different because it will start from when they start work for you. So there will be an ongoing administrative project in terms of monitoring the average hours for the reference periods for each of these hours. Businesses that have significant use of 0 hours or casual hours workers at the moment will obviously be looking at this. It is difficult to know exactly what impact it will have on them. And so in terms of being proactive in this sense, it is really a case of businesses appraising their use of 0 hours and casual hours workers and seeing whether there is a different strategy that they want to consider adopting, albeit there will be some time to consider that before this reform happens. That's all the time that we've got. That's everything I wanted to cover today. I know we've had some questions in there. I'll try and get back to people separately in terms of the questions they've asked, because I'm not able to answer them now. Thank you very much everyone for attending, and good luck for the next 18 months. Thank you.